Welcome to Young Legal Minds. In my last video on contract law, I went over offers, and in this video, I will be going over revocation of an offer. Now, the general principle in relation to revocation of an offer is that it can only be withdrawn or revoked before it is accepted, as shown in the case of Routledge and Grant. So, if it's accepted before it is revoked, then the offeror will generally be bound by the terms of the contract. And if the offer is withdrawn after acceptance takes place, then the offeree who accepted that offer will be able to claim for a breach of contract. So in Routledge, the offer was to remain for 6 weeks, and before the 6 weeks had finished, the offeror withdrew the offer. The claimant then tried to accept the offer, and the courts held that he couldn't because it had already been revoked. Had he accepted the offer before revocation, then that would have amounted to a valid acceptance, and he would have been able to make a claim for a breach of contract. Furthermore, just like acceptance must be communicated to be valid, revocation of an offer must also be communicated, as shown in the case of Byrne, Van Tienhoven. However, an offer can lapse if it is not accepted within a reasonable time frame, as shown in the case of Ramsgate Victoria Hotel, where 6 months of silence led to the offer ceasing to exist. But of course, the courts will take into account all of the relevant factors before deciding whether the reasonable time frame had been exceeded, such as the nature of the offer. One of the most obvious ways an offer can be revoked is through death. If a person dies, then the offer cannot remain. Now, unless the offeree is unaware of the offeror's death and it's not a contract for personal services, as shown in the case of Bradbury and Morgan, then the offer will cease to exist. The general principle is that if the offeror or the offeree dies, then the offer ceases to exist. What about situations where a person makes an offer and the person they made the offer to, so the offeree, then makes an offer to them, back to the offeror? So that would be a counteroffer. Well, that would have the effect of destroying the original offer, rendering it incapable of being accepted. So let's say you make an offer. You say to me, I'll sell you my bike for £300. If I then say to you, I will buy it for £250, I have made a counteroffer. Therefore, I will be incapable of accepting your original offer unless you made that offer to me again. This principle was established in the case of Hyde and Wrench, where the defendant made an offer to the claimant to sell some land for £900 or something around that. The claimant then made a counteroffer in an attempt to buy the land at a lesser price, and when that offer was rejected, the claimant then tried to accept the original offer, but was stopped from doing so because the original offer ceased to exist as a result of the counteroffer. The next thing I'm going to talk about is second offers. Now, do not confuse second offers with counteroffers. Counteroffers are when the offeree makes an offer to the offeror, so that original offeree then becomes the offeror in relation to that offer. A second offer is where the offeror makes another offer after his original one. The question is, would that revoke his original offer? The case of Pickford shows yes, a second offer will destroy the original offer. Now, going back to my earlier example, let's say you made me the offer to sell your bike again for £300, and a third party, a friend of yours or just somebody you know or a family member or anybody, then told me that the offer had been withdrawn. Would that revoke your offer? Is that capable of revoking your offer? Well, the case of Dickinson and Dodd shows a third party must be objectively reliable. So if your friend is known to be clumsy or get things wrong, then that friend of yours will not be objectively reliable in the eyes of the law. He or she may be subjectively reliable to you, but if the reasonable, prudent man does not consider him or her to be reliable, then the offer would not have been revoked. He must be objectively reliable in order for the offer to be revoked. Now, you need to understand that advertisements of unilateral contracts involve things like reward cases. So, return my lost dog and claim £100 reward. That would be an advertisement of a unilateral contract because it's a unilateral offer. That will be a unilateral offer because it's accepted through performance. You do not need to communicate acceptance with these sorts of offers, and acceptance takes place through embarking on performance. The case of Carlisle and Carbolic Snowball shows that these offers are made to the whole world. So they are made to the world at large and anybody can accept. This creates a problem for the offeror. It means it's very difficult to communicate revocation. We know the general principle in relation to revocation of an offer is that it must be communicated as shown in Burnham, Van Tienhoven. However, the general principle in relation to advertisements of a unilateral contract is that if the claimant wants to revoke the offer, then they must take reasonable steps to do so. So what do we mean by reasonable steps? Well, that depends on the facts of the case, it depends on the circumstances. But we can derive an example from the American case of Shuey in USA, which shows that if an advertisement was communicated in a particular way, then it should be revoked the same way. So going back to the lost dog example, if I put posters on the lamppost, the traditional lost dog posters, you put them on the lamppost, then I will be required to take down those posters in order to revoke the offer. Or if it was an online advertisement, I would need to take down the online advertisement or explicitly state online that I have revoked the offer. Now, this is an American case, so it doesn't have any binding authority in the UK, but it's a good principle and it does have implications for future analogous cases that may happen in the UK. So you can use it to support the argument that reasonable steps must be taken, and that reasonable steps include taking the same steps that you made to make the offer. But it's not binding. It would be highly persuasive though. So what about the postal rule, which applies to acceptance? The postal rule is that once you post a letter of acceptance, that acceptance has taken place and is effective. It's valid acceptance. But what about the postal rule in relation to revocation? So postal revocation. Well, this is when it would not apply, as Burnham, Van Tienhoven shows that revocation must always be communicated, i.e. it must be brought to the attention of the offeree. So the postal rule is the exception to the principle in acceptance that acceptance must be communicated. It, however, is not an exception in relation to revocation. Revocation must be brought to the attention of the offeree. The next situation we need to consider is one of a continuing act of acceptance. So if you make an offer to me to sail around the world to collect something and bring it back to you, can you withdraw that offer while I'm halfway there? The case of Errington and Errington shows no, you cannot, because once performance has been embarked on, the offer cannot be withdrawn. The reason I haven't explained the facts of many of the cases is because revocation is really simple. The principles, the legal principles of the cases are very easy to understand, in my opinion. I would recommend that you read the facts of the cases anyway in your spare time, because they do provide real life examples and they just help ingrain those legal principles in your mind so that you remember them. So that's revocation of an offer. Thank you for watching or listening even. My next video for contract law will be on acceptance.